Hello friends, welcome to SRIRAM's. The topic for today's podcast is Right to Silence. What is the right to silence? The right to silence means that if someone is accused of a crime, they have the right to remain silent and not answer questions or provide information that could be used against them in the court of law. It is based on the fundamental principle that no person can be compelled to be a witness against themselves. इसका पर्पस है कि सबको एक फेयर ट्रायल मिले. Does the Constitution of India provide for it? Yes. Under Article 20, Clause 3 of the Constitution of India, a person accused of an offence cannot be compelled to be a witness against themselves. इसका implication ये है कि individuals have a right to silence during police interrogations, court proceedings, or any other legal proceeding. Who exactly can exercise the right to silence under Article 20, Clause 3? Article 20, Clause 3 applies only to those persons who are accused of an offence. It does not apply to a witness, as the witness is not being accused of a crime. What are the exceptions to right to silence? First, right to silence is not absolute. In cases involving public safety or national security, authorities may have the power to require individuals to provide information or to answer questions. This is done to prevent potential threats or to investigate matters of significant concern. 2. In India, the right to silence is limited only to criminal cases. अगर civil cases में भी right to silence होगा, तो ऐसा माना जाता है कि leniency की वजह से crime rate बढ़ जाएगा. Example, if a person is being questioned under the Customs Act 1962 or the Foreign Exchange Management Act 1999, they are not considered accused of an offence, and therefore they are not entitled to protection under the Article 20, Clause 3 of the Constitution. Similarly, under the Prevention of Corruption Act 1988, the accused person for whom unaccounted monies of properties disproportionate to his known sources of income are recovered cannot seek protection under Article 20, Clause 3. Third, judiciary may not sympathize with a person remaining silent in a suspicious manner. For example, if a person chooses to remain silent, their silence itself may be taken into account as evidence of guilt. Additionally, if there is strong evidence against the individual, their refusal to answer questions may be viewed unfavorably by the court or investigative authorities. How is the Supreme Court verdict in Maneka Gandhi v. Union of India case related to it? Maneka Gandhi v. Union of India, 1978, expanded the scope of Article 21 of the Constitution of India and ruled that the deprivation of right to life and personal liberty requires fair, just, and equitable procedure to be followed in criminal cases. इसे ड्यू प्रोसेस फॉलो करना भी कहते हैं. Well, that's all for today. I hope you enjoyed